So what Chris is saying, he's seeing regularly cases where there's a property that's was owned by somebody in the state, somebody passed. Nobody has legal authority today to protect it. They can't borrow against the estate. They cannot even contact the mortgage lender to negotiate anything. The mortgage company won't even talk to them. So we asked the question, can you file ex parte? Ex parte means one party. Can you file, and it's basically like an emergency order where the judge will see you immediately rather than waiting 30 days. Can you go that day and see the judge, or the next day, or 2 days? And will the judge consider stopping the foreclosure? And the answer is yes, if there's a value to the estate. Now, sometimes people try to do that when to do a short sale. You've got to document why should the judge get involved in this. His job is to protect the assets of the estate for the creditors in the county and the state, and then ultimately the heirs. So if they're going to make money in the deal, great. If they're not, if it's just paying commissions to realtors, and they're very aware, very sensitive, looking for, am I doing this just to put money in the realtors' pockets because they hate us? And investors. Hate realtors. So the answer is yes, I've seen it done many times. The key to that, and you can get temporary letters. Sometimes the reason why letters aren't issued, there's two reasons why I find. One is they went to an attorney who doesn't know probate, and he just jerks around the paperwork and makes a mess of it. Big mistake. Go to easy-probate.com. They'll fix it up. The other is there's two people fighting. Neither has been yet awarded because they're arguing over who should get control. They can agree on a temporary administrator, one or the other, or a third party. Could be an attorney. Third party could be a realtor. I've done it. Where you'll say, I'm going to sell the property, but all the money goes into the estate. Nobody has any control over the money. You don't have an estate account set up yet, so it has to get held in escrow until such time you can even open a checking account. But in reality, you could sell houses today in 10, 20, 30 days and have that money put together before the court even meets again next time. But the short answer to your question is, because something's in foreclosure and it looks like it's all over, it's not all over. There is a mechanism to get to the court called ex parte. It's like an emergency where you file in a day or two, and the judge will consider granting you temporary letters to sell the house or list the house. Or maybe you have an offer. I've seen this done. I've done this. We had an offer, and we filed an ex parte to accept the sale of the property, the court to confirm the sale on the spot. Now, they don't like to without appraisals done by the court called the probate referee's inventory and appraisal report. They don't like it without publication of sale. So sometimes you give them the choice. We could accept this offer now and avoid foreclosure, or grant us a temporary authority, and they'll grant you temporary authority. But I've seen that approved many times.